Welcome to meeting number 37 of the House of Commons Standing Committee on Justice and Human Rights. So just before we get into our study on the Victims' Bill of Rights, I'll just remind members of a couple of housekeeping items. First and foremost, if you are requiring interpretation, just take a look at the bottom of your Zoom screen. You will see a globe icon. Please select the language that you'd like to listen to. You can speak in any of our official languages. And secondly, when you are speaking, please ensure that your microphone is unmuted and please speak slowly and clearly. When you have finished speaking, please make sure that you are back on mute. Mr. Clerk and I will do our best to ensure a speaking list and a speaking order. So please raise your hand if you have anything to raise. Thank you for your cooperation on this. Now, before we start our study on the Victims' Bill of Rights, we have to approve the report from the subcommittee, the meeting that we had on Tuesday. The report was distributed to all members electronically yesterday. Are there any comments on it? And if members agree with it, then we'll go ahead and carry it. I'll see a thumbs up for carrying the report. Okay, great, and so carried. And just a note to members and witnesses, at the same time that this committee meeting is happening, there is a virtual ceremony commemorating the release of the National Action Plan for the Missing and Murdered Indigenous Women and Girls, coinciding with the second anniversary of the release of that final report of the Missing and Murdered Indigenous Women and Girls and the 2SLGBTQIA+ report. So thank you, members, for being here today. I'll just invite our witnesses now at this point for being here with us to speak about the Victims' Bill of Rights, which I feel is very fitting on this anniversary. We have with us the Department of Justice, represented by Carole Morancy and Stephanie Bouchard. We also have the Department of Public Safety and Emergency Preparedness, represented by Julie Thompson and Suzanne Wallace Capretta. And we also have the Parole Board of Canada, represented by Ian Broome, and the Correctional Service of Canada, represented by Kirsten Gagnon. Welcome to all of our officials. And I do note that the Correctional Service of Canada and the Parole Board of Canada will not be offering opening remarks today. And so we'll go ahead and we'll start with the Department of Justice. And as I'm sure you're aware, I have this 1-minute card and this 30-second card that will help you in keeping time for your 5-minute opening remarks. So Madame Morancy, please go ahead for your 5 minutes.
Thank you. Nous sommes heureuses de...
We are happy to be here today to discuss the Canadian Victims' Bill of Rights and related efforts by the Department of Justice. Ensuring access to justice for victims of crime and giving them a more effective voice in the criminal justice system has been a long-standing commitment of the federal government.
Legislative and programmatic measures in support of this commitment have been coordinated through the Federal Victims Strategy. Established in 2000, this horizontal strategy is led by Justice Canada and includes Public Safety, Correctional Service Canada, the Parole Board, and Public Prosecution Service of Canada. The Canadian Victim Bill of Rights, or the CVBR, is an important cornerstone for continuing federal efforts to support victims of crime. Enacted in 2015, the CVBR gives victims of crime 4 statutory rights: the rights to information, protection, participation, and to seek restitution. These rights apply throughout the criminal justice process. The CVBR also requires, to the extent possible, that all federal statutes be interpreted in a manner consistent with victims' rights under the CVBR. It provides a complaint mechanism for victims to file a complaint when these rights have been breached by a federal department or agency. As the committee knows, responsibility for our criminal justice system is shared between the federal and provincial territorial governments. The federal government is responsible for the criminal law and procedure, much of which is set out in the Criminal Code, as well as the Corrections and Conditional Release Act. Provincial territorial governments are responsible for the administration of justice, which includes enforcing and prosecuting criminal code offenses, the delivery of victim services, and enacting their own victim legislation. Since 2015, there have been significant individual and collaborative measures taken by all governments to advance and strengthen the implementation of victims' rights. For example, at the federal level, early actions to support the right to information focused on creating a series of fact sheets about victims' rights and related criminal code provisions. These have recently been made available in 11 Indigenous languages. Federal funding was also made available to provincial and territorial victim services to create or update their public legal education and information materials for victims, victims advocates, and criminal justice professionals, in addition to training on the CVBR. The right to information has also been supported through the design and delivery of new models of victim-centered services. The creation of family information liaison units across Canada in 2016 has ensured that family members of missing and murdered Indigenous women and girls have all the available information that they are seeking about their loved ones, as well as access to community-based supports. Justice Canada has also supported the right to participation through funding to the provinces and territories for their purchase of testimonial aids to facilitate victim testimony. Victims' rights to information, protection, and participation have also been supported by federal funding for independent legal advice and representation programs for victims and survivors of sexual assault, which are currently being piloted in a number of jurisdictions in Canada. Justice Canada has also worked closely with provincial and territorial victim services to fund their design and delivery of jurisdiction-specific restitution programs. Law reform continues to be an important tool to affect change and to implement victims' rights. In addition to the criminal law reforms that accompanied the CVBR, some recent legislative reforms support victims' participation and protection rights. For example, the recently enacted Bill C-3 requires candidates seeking appointment to a provincial superior court to participate in continuing education in sexual assault law and social context, and requires judges to provide reasons for their decisions in sexual assault cases. Former Bill C-75 on delays enhanced victim safety, particularly for victims of intimate partner violence, including at bail and sentencing. It also reenacted a new victim surcharge regime which is an important source of revenue for PTs, and in response to the Supreme Court's decision in Boudreau. Following the enactment of the CVBR, federal departments and agencies whose mandates involve working with victims of crime have implemented formal complaints mechanisms for victims. Justice Canada prepares an annual report and complaints and is published online. Provinces and territories also have their own areas, their own complaint mechanisms. Those are the items I'd like to highlight for Justice Canada. Thank you.
Thank you very much, Madame. We'll now go to the Department of Public Safety. Please go ahead for 5 minutes.
Good morning. Thank you very much for having me today. Merci de m'avoir invité pour faire.
Thank you for inviting me to share with you the work of Public Safety Canada in order to support the implementation of the Canadian Victims' Bill of Rights Act.
Colleagues from Correctional Services and the Parole Board of Canada, who also have roles to play in upholding victims' rights under the CVBR. Public Safety Canada is responsible for the Corrections and Conditional Release Act, which guides CSC and the PBC on how federal sentences of over 2 years or more are carried out and give life to rights that can be exercised by the victims of federal offenders. Within public safety, the National Office of Victims is a resource working to improve victims' interactions with the federal corrections and conditional release system by supporting a victim's lens during policy development, sharing information through the development of products with victims and the general public regarding federal corrections and conditional release, such as the publication entitled Victims of Crime, Staying Informed booklet, which is available in 20 languages, including 7 Indigenous languages, and supports and complements the work of the Policy Centre for Victims Issues at Justice Canada through portfolio coordination and engagement with victims and other key stakeholders. In addition, the National Office for Victims and Public Safety Agency partners have developed a number of information products to ensure that victims are aware of their rights and the services provided to them by the federal government. Nous nous efforçons d'améliorer.
We continuously strive to improve these products and develop new ones thanks to feedback from victims.
Appropriate redress is a key element of the CBVR, which established a means by which victims can complain directly to federal departments and agencies if they feel their rights have been denied or infringed, in order to address issues quickly and with satisfaction. Should a victim not be satisfied with the outcomes of a complaint, they can contact the Office of the Federal Ombudsman for the Victims of Crime. As part of its coordination role, the National Office of Victims annually publishes information on CBVR-related complaints to the public safety portfolio agencies and public safety itself regarding how these complaints were resolved. Since the coming into force of the CBVR in 2015, the National Office for Victims has also held annual roundtables between 2016 and 2020 with victims, their advocates, and victim-serving organizations to discuss the implementation of the CBVR in the context of federal corrections and conditional release. Themes raised at these tables are broad-ranging. Examples of themes include accountability, offender reintegration, restorative justice, and outreach and engagement. Summary reports of these discussions are all available online at the Public Safety Canada website. Il est important de mentionner.
Importantly, we heard that it has been brought to our attention that information is essential for victims so that they are able to exercise their rights to participation and protection.
2020, CSC provided information to some 8,800 victims who requested information about the offender that harmed them. The public safety portfolio is committed to implementing the CBVR to ensure victims of federal offenders are treated with compassion and respect, including receiving timely information required to exercise their CBVR rights. Recently, an internal audit by Correctional Services of their National Victim Services Program found that Correctional Services offers services to victims in compliance with all relevant legislation, policy, and procedures. To further consider victims' needs in their operations, the Parole Board of Canada has established a National Victims Advisory Committee, and CSC has launched an internal victims engagement task team to ensure greater consideration of victims' concerns in decision-making. I would also like to acknowledge that the current COVID global pandemic is a difficult time for vulnerable victims and families. To ensure victims' rights have been respected, corrections and conditional release operations have had to pivot and use new methods and practices to fulfill their mandates in a way that conforms with public health and safety protocols. We acknowledge more can be done, and as such, we're committed to working with stakeholder suggestions from roundtables to do this. Thank you for the opportunity to appear today. Je vous remercie.
Thank you very much.
Thank you very much for that, Ms. Thompson. We'll now go into our rounds of questions. And just for members, just to note that we do have the Parole Board of Canada and Correctional Service of Canada that are here with us today to answer questions as well, should you have any for them. We'll start with our first round for 6 minutes each with Mr. Moore. Mr. Moore, please go ahead. You have 6 minutes.
Thank you, Madam Chair. I think Madam Finley or Mr. Cooper were going to be up this round, so I don't want to take somebody's spot. I think it was Mr. Cooper.
Yes.
Okay, Mr. Cooper, right. Please go ahead.
Okay, thank you very much, Madam Chair, and I will direct my questions to the Parole Board witness. I want to first of all just say that the passage of the Victims' Bill of Rights is a significant step in the right direction to protect the rights of victims that have so often been overlooked in Canada's criminal justice system. And in that regard, I want to certainly acknowledge the important role that Senator Pierre Boivenu, who I consider a friend, played in advancing the Bill of Rights, Victims' Bill of Rights. Senator Boivenu, of course, a victim himself, his daughter having been brutally murdered. But as the report of the Victims Ombudsman demonstrates, there are still serious gaps in terms of seeing that those rights are in fact realized in practice. And one of the areas of concern is with respect to a lack of transparency, or a perceived lack of transparency, when it comes to the right to information to victims in respect of parole board hearings. And I want to just touch upon that because Carol Freeman, whose father was brutally murdered in Oshawa, Ontario in 1991, was caught off guard when she suddenly received notice that the man who had brutally killed her father, who had been sentenced to life in prison without eligibility for parole for 25 years, that suddenly he was up for parole after serving only 20 years. And she had not been provided any sort of explanation about the dates or conditions that resulted in his eligibility for parole. So I would just ask the parole board representative to just discuss that because it is a common concern about victims who are caught off guard with respect to dates and being informed with very little notice of parole hearings, which are often very difficult experiences for victims, particularly in instances of brutal crimes like murder.
Thank you. So, can you hear me?
Yes.
Okay, so I'd just like to begin by saying that, the parole board is definitely committed to openness and transparency in the way that we provide information and we ensure participation of victims in respect of the conditional release process. And in terms of information that registered victims can receive, so we may end up touching on this a little bit more later through the course of the meeting, but there is a victims portal that's in place where registered victims can access a variety of information. So for example, they can receive information regarding the offender's name, the offense, court of conviction. In addition, there is access to information such as the eligibility dates for release. So I would say that when victims are registered and they do seek this information, that there is a fair amount that can be received. So, the date of the release, for example, unescorted temporary absence, the board has approved this. The reasons behind this. And in addition, victims can also request a copy of decisions through the decision registry.
Yeah, sorry to interrupt. And I should just correct for the record. I think I said Carol Freeman. I meant to say Lisa Freeman. So I just want the record to be corrected in that regard. Well, I mean, Ms. Freeman said, quote, that there are no supports in place, but she basically felt she was on her own because there was no transparency about the reasons for that eligibility date, which was, again, 5 years ahead of what she thought. She thought she had 5 years, and then all of a sudden that notice came. So would you not acknowledge that that is an issue?
I would acknowledge that there is a great deal of importance in ensuring that victims, are able to receive the support and information that they require throughout the hearing process. And our regional communication officers are there to work with victims to provide information and answer questions throughout the entire hearing process. And in addition to refer any victims who are experiencing, for example, trauma to appropriate services.
I see my time's expired.
Thank you very much, Mr. Cooper. We'll now go to Mr. Kellaway for 6 minutes. Please go ahead.
Thank you, Madam Chair, and hello, colleagues, and thank you to all the witnesses for your testimony today. I think this study is very important. As members of Justice Committee, and of course parliamentarians, it's really incumbent on us to hear the testimony from officials and groups and individuals on how victims of crime, how they can be better supported. So my first question is to Ms. Morrissey. I understand that through the Victims Fund, we've made more than, I think it's $20 million available to provincial and territorial governments and non-governmental organizations. So can you take some time to talk about some of these projects and how they've benefited Canadians?
Yes, actually, I'll start, and if I may, I'll turn to my colleague, Madame Bouchard, to continue. One, to start with, the federal government made available through the Victims Fund for provinces and territories approximately $10.6 million over the year from 2016 to 2020 to help support implementation of the CVBR in their jurisdictions. And that's in addition to funding that's otherwise provided through the Victims Fund more specifically. And maybe ask my colleague to provide a bit more details on some examples of how the federal government has funded different provinces and territories through their annual agreements and G's and C's.
Yes, hello. So the federal victim strategy includes the Victims Fund, which is a fund that provided from 2015 to 2020 $125 million to support different projects and initiatives to provide for victims and different issues to help support them in different aspects of it. It's a grants and contribution program, which is made available to PTs and also to groups and organizations. And through this Victims Fund, as mentioned in the speech presented by my colleague, Ms. Mahasi at the beginning, the Family Information Liaison Units have been supported through it since 2016. We are supporting a number of initiatives, including the independent legal advice and independent legal review programs that are being piloted across the country, and who will have been announced in the budget that there will be increased support and funding throughout. So they're all projects aimed at providing supports. PTs themselves have agreements that are specific to them, and they are made for them to provide what their needs are based on their assessment of the situation in their province, in different areas of their different communities, rural, non-rural cities. So there's a lot of flexibility and work being done with the whole objective of improving services for victims, including information supports that can go from ensuring cell phones being provided to more remote communities when there's need and such. Don't know if that provides enough context, but
no, it does. It really does provide a bit of an in-depth lens on it. Appreciate it very much. This could be for Ms. Morrissey, yourself, or others that want to chime in, but I think primarily be for you two. The government created a federal victim strategy to support the Canadian Victims Bill of Rights. And again, I'd like to have you or others talk about some of the initiatives that were part of that strategy. I think it's important for Canadians to hear, the ins and outs of that particular strategy and initiatives attached to it.
Well, again, as I mentioned in my opening remarks, the federal victim strategy has been in place since 2000. It's gone through a number of updates and modernization and overhaul. Key components to that strategy at the federal level, coordination of the different departments and agencies that have mandates to work with victims. I've mentioned some of our key partners, and some of them are on the meeting today with us. Also, key partners in delivering on the strategy are the provinces and the territories, with whom we work very closely to share information, best practices, is identify gaps, whether they're gaps in services, whether they may be gaps in law, or maybe there are new or different trends developing that we can work together on to address and better support victims throughout the country and throughout the criminal justice continuum. So as my colleague has just noted, much of that work occurs through FPT meeting forums. We have funding agreements. We have a grants and contributions program that's available to organizations that serve victims as well. So all of that is done under the auspices of the Federal Victim Strategy, and funding as a key component of that.
Wonderful. Madam Chair, how much time do I have left?
8 seconds.
Okay, thank you very much for your testimony. Very much appreciated.
Thank you, Mr. Calloway. We'll now go to Monsieur Fortin for 6 minutes. Please go ahead, sir.
Merci, Madame la Présidente.
Thank you, Madam Chair, and thank you to the witnesses for being here today. Now, Ms. Morancy or Ms. Bouchard, I think it was Ms. Bouchard earlier who said how much money per year is transferred to the provinces when it comes to assistance to victims or the families of victims of crime. Can you give me that figure, please, of the transfers to the provinces?
Oui, bonjour.
Yes, good morning. I cannot give you the exact amount for each of the agreements and how much is transferred under each of these agreements to the PTs, but it's an amount that I could confirm with my colleagues with whom we work very closely, who actually manage those funds from a monetary point of view. Has that amount varied since 2000, or is it always the same amount? Well, as you no doubt know, the funds and the monies granted or approved by the Treasury Board. Madame Bouchard, I don't want to interrupt you. I'm not being polite here, but we don't have much time. I'd just like to know whether, as far as you know, and you can say no if you don't know, but do you think that amount has increased over the years, or has it been the same amount since the year 2000? The amount has significantly increased. All right. Okay, thank you. And now, Ms. Bouchard, during the pandemic, has that had an impact on the budget when it comes to victim assistance or the families of victims? Yes, the pandemic has had an impact on several aspects for victims in the provinces and territories. Have also invested and contributed a great deal of money on the federal side as well in order to respond to this specific immediate need because of the new situation. So it's cost more over the last year and you've invested more money compared to previous years. Is that a correct summary? No? Well, I cannot speak about my Victims Assistance Fund because that's fixed under the terms and conditions of the fund itself and the money allocated by the Treasury Board. But there's been lots of inflows, other inflows. So you don't know if there's been more money increased for victims' assistance over the last year or if it's like the year before. You cannot give me an answer on that. Well, perhaps. Yes, Ms. Morancy. And thank you, Madame Bouchard. Well, just to add something, it's true that the federal government has announced funds to support victims during the pandemic.
Provide the committee with some information about the funding provided by, particularly announced through the Women's Equality Ministry.
Merci, Madame Morancy.
Thank you very much, Ms. Morancy. I'm going to change subject, but perhaps it would still fall to one of the two of you. Now, I don't know which one of you can talk to me about the different programs that exist to help victims' families and victims. What type of programs are there? And then I'd like to ask how they've evolved since 2000 and what's been added.
Bon, Madame Bouchard, peut-être vous n'avez pas l'air sûr qui va répondre.
Ms. Bouchard, would you like to jump in first? Yes, sorry, I had some trouble with my button there to switch on my mic. On the federal side, there have been developments with different services working in partnership with different provinces and territories. There's been a lot more information and helping also with children. But in terms of programs, Ms. Bouchard, sorry, I know I'm not being polite there to interrupt you, but 6 minutes rush and probably I've only got about 2 left. So I'd like to know, I know that there's psychological assistance programs for victim or victim's family, and probably there are also assistance programs to get legal advice. You've said to advise people, to give them advice. So could you list the different programs that currently exist to help victims or families of victims? If you're not able to do that, just let me know. The only thing I can say is that with the immediate administration of justice system for the provinces and territories, there are different programs stretched across the country that are directly linked. So it does vary from one province to another, and your role is to ensure that there's a transfer of funds to the provinces. And I've also understood, Ms. Morency, that you're going to give us a breakdown of the sums transferred to provinces when it comes to aid to victims and their families since 2000. You're going to transfer that to us, I hope, soon? The hearings are going to finish next week, so perhaps you could send it by the beginning of next week. What do you think, Ms. Morency? Would that be possible?
Je pense qu'il y a un problème de connexion pour Madame Morency.
I think there's a connection problem for Ms. Morency. Well, I'll answer then. Yes, we should be able to give you those figures. Thank you very much, and I know my time is up. Thank you.
Thank you very much, Monsieur Fortin. I appreciate that. We'll now go to Mr. Garrison for 6 minutes. Please go ahead.
Thank you very much, Madam Chair, and I want to give a special thanks to all our witnesses for being with us on this important study at what was, I know, short notice for them. The fact that we're commencing this study this week does raise one of the concerns I've always had about our approach to victims' rights, in that it has been focused on individual victims and individual cases. And so I thank the chair of the committee for mentioning missing and murdered Indigenous women and girls. This morning, we know that many thousands of women and girls have been lost to Indigenous communities, never to return. Also this week, the discovery of the 215 bodies of children at the Kamloops Residential School, and the many hundreds of children who died in residential schools and their families are also victims. And we also have some categories of Canadians which are more likely to be subject to high levels of violence in terms of becoming victims. And that, of course, includes transgender Canadians, other members of the SOGI community, like the racialized members of the Toronto community, which were subject to a gay serial killer for more than 10 years, subject to high levels of violence in Canada. So I know it's a long preface, but here's my question. Because the Act and the funding seem to be focused on services to individual victims, and that's very, very important, I want to ask about support to victims organizations and community-based victims organizations who quite often are able to work with and serve those larger communities of victims, if I can use that term, and help communities cope with the toll both of loss in the community, but also with the challenges of the legal system in terms of achieving justice in those cases. So that's my real question. Do the funds actually serve community-based and victims organizations as well as individual victims?
If I may, yes, the funding does support victims organizations and community services. They're not simply targeting individuals themselves, but go to bigger and broader initiatives such as the family information liaison units that have been mentioned, as well as child advocacy centers. the fund receives applications also for different, initiatives, promising practices. It's wide breadth.
And have the funds been adequate to fund all of the requests for service that you have evaluated as positive applications, or are you in the unenviable position of turning down some very good requests?
There are, of course, there's always different needs, but we do the best to allocate the funds as to the maximum capacity that we're provided with for the year. And there are new, announcements in the budget that will increase a lot of the funding for some of these initiatives that have been announced recently, in particular for the independent legal advice for sexual assault victims.
But really what we're saying now is that what that acknowledges is that there have been some unmet needs in the past. And so certainly an increase in funding is welcome to help meet those challenges. I will grant you that. Among those victims organizations, is there support going to victims organizations from Indigenous communities across the country? And is there any support going to residential school survivors? Because we do have the unfortunate situation where the federal government is fighting in court against some of those residential schools survivors. And so are they as victims receiving support at the same time for those legal challenges? Is anyone aware of any support going?
Sorry, I was waiting for my colleague. Maybe I would say, for sure, a big part of our recent efforts, and since 2016 through the Justice Canada, has been support through the FILUs, the Family Information Liaison Units, for the survivors and the victims of the murdered and missing Indigenous women. In addition to that, we do continue to work and look at, for example, working with individual communities to even more lessons learned about some of the different issues that have been identified as ways to improve responses on a go-forward basis. And of course, we work with the provinces and territories who directly engage and provide support to individuals, and work with community organizations and communities in their jurisdiction as well. I don't know if my colleague had anything else to add.
Not hearing anything, maybe I'll just ask very specifically. The residential school survivors from St. Anne's are in a kind of David and Goliath court struggle. Is legal assistance funding being provided to the residential school survivors from St. Anne's in their fight with the federal government in court?
I'm not aware. I'm not in a position to respond to that. It could be that it's outside of the victim's strategy, but we're not in a position to comment or answer the question.
Thank you very much. Thank you, Madam Chair.
Thank you very much, Mr. Garrison. We'll now go to our second round of questions, starting with Madam Finley for 5 minutes. Please go ahead.
Thank you, Madam Chair, and thank you to the witnesses for being with us today. This is an important topic. I'd like to begin by noting that Section 2.1 of Bill C-32, the Victims' Bill of Rights Act, called for a parliamentary review to be conducted 5 years after the bill's coming into force. As we all know, July 2015 was 6 years ago. That comprehensive review needs to take place separate from our study. So for victims and their families is something we should all care deeply about. I believe we do. So I'm glad we are at least taking the time to study it here. This is for the Department of Justice officials, Ms. Morency or Ms. Bouchard. Under Section 515, sub 13 of the Criminal Code, added through Bill C-32 with respect to bail hearings, justices are now required to include in the record a statement that the justice, quote, considered the safety and security of every victim of the offense, end quote. Could you speak to the impact this new requirement has had on the safety of victims over the past 6 years? Either one of you.
Hello. As you will know, the CVBR is the overarching bill, and when it was passed, also a number of criminal code amendments were provided. There have been many changes to their criminal code to provide for different measures, including testimonial aids, publication bans, and accompanying all those legislative measures aim to provide more security for the victims. There have been investments. Through the Federal Victims Fund, money was provided to PTs who purchased more testimonial aids. We're able to adapt different rooms for them to wait. Some have improved some of the rooms in this pandemic to be bigger, to be able to have the victim support and still maintain the social distancing.
All right. Thank you. Clause 29 of the bill now requires the court to consider making a restitution order in all cases, not just fraud, and if not granted, include reasons in the record. This is section 737.1 of the Criminal Code. Had this reform led to more restitution orders since its enactment? Do we have any data on this?
If I may, we have just we are currently monitoring the case law to see if, in effect, it has it's the amendments to the criminal code are having the impact that was envisioned when they were implemented, to ensure that the victim is not forgotten and that there's a real attention paid to restitution. We're still analyzing the data. We're working with criminal justice StatsCan. It's a difficult, as you know, and I'm sure the committee is aware of the data difficulties based on the different PT's system of collecting data. So we're still in the process of, assessing and looking at whether or not the impacts. The civil remedy and enforcement measures are under the PT Administration of Justice, and funding also was made available through the Victims Fund to help support them implement restitution programs in order to facilitate collection of enforcement of the orders that have been made by judges for them to be reimbursed for some of the readily ascertainable losses that they might have made.
Thank you.
Gotten.
Thank you. Section this again, or the parole board official, Section 15 of the Victim Bill of Rights sets out every victim has the right to present a victim impact statement to the appropriate authorities. Clause 49 provides victims may present that at conditional release hearings. Impact statements help with decision making, but also important to victims in coping. I'd heard in October of a victim's family being told that because of the pandemic, they wouldn't be allowed to give their impact statement in person. Without reference to any specific case, do you see this as a violation of victims' rights, and was this happening in every province during the pandemic?
If I can respond to the question.
Yes.
So I would say that, throughout the pandemic, the Parole Board of Canada has ensured that we've respected the legislative rights of our victims. And in terms of participation, victims have been able to submit statements and have the statements considered by board members. In respect of hearings where a victim statement is to be read, initially in the pandemic, in the early days, it was a challenging time, I think, for us and for others technologically. But what we ended up doing is we put in place a stable and secure teleconference system. And then we shifted to a video conferencing solution, which was piloted towards the end of 2020 and then was launched nationally in 2021. So since that time, the board has facilitated participation over 500 victims and at over 300 hearings. So actually 12% more than the year before. And specifically in terms of presentations.
I'll stop you there, Mr. Broom. My apologies. We're a minute over. We'll go next to Mr. Maloney.
Thank you.
Please go ahead for 5 minutes.
Thanks, Madam Chair, and thank you to all our witnesses. This is I'll say what many have said, this is an important discussion. Victims' rights are paramount. It occurred to me when we were getting ready to have this discussion today, some of the comments that were made today reinforce this notion. Mr. Cooper was talking about transparency of the parole process. Ms. Finley was just alluding to it. I don't think, and correct me if I'm wrong, but children of the criminals themselves, I would argue, are victims of crime too. But I don't believe they are considered under this legislation. Is that true? Anybody want to? It's a yes or no question.
Specifically to anyone, Mr. Maloney?
Well, anybody who can answer the question would be. Children of people who have committed crimes do not benefit under this legislation as it currently stands. Is that fair?
The definition of victim is provided in the CBR and in the criminal code. It's wide. It depends on the correlation. If the children of the offender were offended themselves by the offender who's been
yeah, okay. So I looked at the definition, and I don't see that a child of somebody who is in prison who's committed a crime would fall under the definition of victim. But if you're talking about things like parole hearings and benefits available and access to information, there are situations where children have parents who have committed crimes of whatever nature who are now suffering through no fault of their own. Would you think, anybody can answer this question, would you think it's a good idea that they be incorporated into the definition of victim somehow?
If I attempt to just offer some information in response to this question. While I can't offer an opinion on whether or not the definition should be adjusted to include children, I did want to offer that there are some information publications that are available to children who have parents who are being incarcerated. And not to put my colleague from Correctional Services on the spot, I've forgotten the name of the organization that provides that service, but happy to provide it. But wondering if Correctional Services might
you might be referring to KIP Canada, Kids of Incarcerated Parents. That's one organization I know of, but I see Ms. Wallace is shaking her head.
It's the Canadian Corrections and Family Network, who we work closely with.
Okay, so are there structures in place then that do work with children of perpetrators then? Is that along the same lines as might be considered under the Victims' Bill of Rights?
They do, yes.
Okay. All right. What would you say of the enumerated rights under the legislation? What would you say the biggest benefit has been? Which right, if I can put it that way, has been has served to be the most beneficial and had most use since the legislation was passed in 2015? Ms. Morency?
If I might take a stab at part of the answer, in terms of we are still awaiting some research that's in the process of concluding, being wrapped up. So we hope to get some better information in the months to come. But one of the things that was really important in the development of what became the CVBR, there were quite a few consultations held by the government, the minister at the time, with Canadians, victims themselves, victims serving organizations. And one of the issues that was incredibly important to them was the importance of information along the continuum of the criminal justice process, and the importance of being able to participate, to be consulted, engaged by police and Crown on the progress of their case throughout the system. So to the extent that those were important in developing the CVBR, and that the CVBR recognizes those rights and enhances the opportunity to receive that, I would say it has been successful, but we await the research.
Okay. This is an unfair question with 20 seconds left, perhaps, but does the legislation apply to victims or family members of victims of crime that have been committed abroad? And if so, what is your experience with dealing with that? Maybe just answer the first part of that question, somebody.
Yes. Sorry. Is that may I continue, or I'm hearing a?
That was my timer, but quick answer.
Okay.
I'm sure the chair will.
Very, very briefly. Thank you.
Victims victimized abroad have funding through the Federal Victims Fund to help support them, and jurisdictions such as the province of Quebec have just amended their provincial victim legislation that's just come to pass and will be enforced by the fall, and they now recognize and will be providing services to victims who are victimized abroad, and for them to have services offered at the provincial level, full services for them when they return to the province of Quebec, their province of residence.
Thank you.
Thank you
Thank
very
you,
much.
Madam Chair.
Thank you, Mr. Maloney. We'll now go to Monsieur Fortin for 2.5 minutes. Please go ahead, sir.
Merci, Madame la Présidente.
Thank you, Madam Chair. I'm sorry for being impolite in advance, but 2.5 minutes finishes before it starts, almost. I don't know who can answer, perhaps Ms. Bouchard or Ms. Morancy, but can you talk about the services that are offered? I liked what Mr. Maloney said there. I'm picking up on that. So I'm talking about services offered to families of people who have been found guilty and also abroad. For example, if you've got a mother where the son has been charged and found guilty and is held abroad, would she be able to enjoy services here in Canada to help her in defending her son and questions of transfers and so on? Each province and territory have their own victim aid services because they're responsible with offering the direct services to victims. There's different organizations, different measures and different programs that exist. It really varies a great deal. But in terms of the Bill of Rights, you've said the definition is quite wide. We talk about individuals that suffer damage because of the commission or alleged commission of an offence. So I think that would include families of criminals as well as families of victims of crime. Those who are suffering consequences would be covered. But I'd just like to check that it is correctly understood that this is something that exists, that the funds granted by the federal government to the provinces and territories include assistance to families of those who have been found guilty of committing a crime. Is that your understanding as well? Are you finding people, talking about people who've been found guilty in Canada or abroad? Well, you can make a distinction, but I'm interested about this. What do we do for families of people who have been found guilty? The victim assistance support is very varied and it's very present across the country at different scales. We have lots of requests each year from families of people who have been found guilty of committing a crime. Does it happen often? I think it's frozen, the screen. Well, unfortunately, I cannot answer that question. Ms. Morency, please, would you be able to answer that? No, I understand that no one here is able to talk about that question with me. Now, as far as you know, are there amendments you think that should be made to the bill as it stands, or do you think that there's no request for this and we can live well with the current text of the bill? Ms. Bouchard or Ms. Morency? Any amendments or not? Well, are you comfortable with it? I'm afraid the sound is cutting in and out. I think I've got a problem with my network. Ms. Morancy, I imagine we've just got a few seconds left.
You don't have a few seconds left at all, Monsieur Fortin.
Madam Chair, there was about 1 minute that was taken up with technical problems, so out of 2.5 minutes, I had a real limit there.
It's now, Monsieur Fortin. So you've had a minute extra, but I appreciate your passion on this. I thank you so much. We'll go to Mr. Garrison now for 2.5 minutes. Please go ahead.
Thank you, Madam Chair. I want to go back to justice officials. This week, Justice Fish released his report on military justice. It's a 400-page report. I don't expect everyone in the country to have read it. I've only managed to make it through one read myself. But one of the things he talks about is the fact that victims in the military justice system do not have the same rights as they do in the public justice system. Partially, Bill C-77 hasn't fully been proclaimed, even though it was passed 2 years ago. But what he suggests is that there should be some kind of joint working group between justice and defense to try and harmonize or make sure that the National Defense Act provides the same victims' rights protections that are provided in our civilian system. And so are either of you aware of any work that's gone on with the Department of Defense on trying to make sure that victims' rights are fully implemented in the military justice system?
If I might try to briefly respond. Since the development of what became the CVBR and Bill C-32, Justice Canada has worked closely with the Department of National Defence in developing what became the civilian VBR. They weren't in a position to bring forward similar amendments on their part because it's a much more complicated regime. And as you note, Bill C-77 is still to come into force. We do continue to work with them on various criminal code reforms, including on victim support and including over the last few years on in supporting particular interest on how to support victims of sexual assault and that through the process. On a go-forward basis, I think the government has indicated that they will work to address that, and we in the Department of Justice will do our best to support the government moving forward in addressing the issues as best as we can.
Thank you for that answer, and it's very good news indeed. One of the things that Justice Fish says, which I know that you will not be able to comment on, but I will comment on, is that until the victims' rights in the military justice system are the same as those in the civilian system, that sexual assault cases should not be handled by the military justice system. So I want to thank you for that work that you're doing with the Department of Defense and acknowledge that it's very, very important work. And with that, I'll end my questioning, Madam Chair.
Thank you very much, Mr. Garrison. On the dot with your 2.5 minutes, I appreciate that. And that does conclude our round of questions. And just before we suspend for the next panel, I just really want to thank MP Tim Lewis, who joined us today, replacing Mr. Virani for a little bit there. Thank you so much, Tim, for joining us in our justice meeting today. So we'll go ahead and suspend as we let in our witness for the next hour. So be prepared for about 1 to 2 minute suspension. Thank you, everyone. Thank you to the witnesses for being here today and for your very compelling testimony. Thank you.
Thank you.
And she knows the rules, but we'll just reinforce them so everybody's aware. When you are speaking, please ensure that you are unmuted and that you speak slowly and clearly for interpreters. When you are done speaking, please ensure that you are back on mute. You do have language translation services that are available to members. The bottom of your screen, select the language that you'd like to listen to. You can speak in any of our official languages. And with that, I would like to welcome Ms. Illingworth, who will be providing opening remarks for 5 minutes. And for members who don't know, she is from the Office of the Federal Ombudsman of Victims of Crime. Welcome and thank you for your time, Ms. Illingworth. Please go ahead. You have 5 minutes to make your opening remarks.
Thank you. Merci, Madame la Présidente. I want to begin by expressing my sorrow for the Indigenous families who are grieving the discovery of 215 children found in a mass grave at the residential school in Kamloops. I stand in solidarity with all Indigenous peoples seeking justice. Today, we also mark the release of the National Action Plan on Missing and Murdered Indigenous Women and Girls and 2S LGBTQIA+ people in response to the calls for justice of the National Inquiry released 2 years ago. And I am just here from that ceremony, actually, that's ongoing right now. But it's timely that I'm here this morning to discuss the Canadian Victims' Bill of Rights, which came into force in 2015, because more than 5 years later, a number of fundamental gaps and challenges remain for victims, especially racialized and 2S LGBTQIA+ people. It is our view that the CVBR must be strengthened to better support all victims and survivors of crime. Last November, my office launched a progress report on the CVBR, and it was informed by what we hear every day from stakeholders in our frontline work. So survivors, and then people who work with victims, criminal justice personnel all across the country. And based on our analysis of the data available to us, the justice system really falls short on delivering the promised rights. And it is time to conduct a statutory review of this legislation. Every year, more than 2 million Canadians report criminal incidents to the police, almost a quarter of which are violent. But we don't know how many of these victims are being informed of their rights at all, let alone whether these rights are upheld as they make their way through the justice system. I believe that the right to information is a foundational or a gateway right. And without information being provided to them, victims are unable to access any of the other rights outlined in the CVBR or any other legislation. Currently, victims only receive information upon request, meaning that they must know to ask for it. However, unless an official actually tells them they have rights, they are unlikely to know that these rights exist. It is my view that criminal justice officials must be mandated to inform victims of their rights. As written, the CVBR puts the onus on victims to know, understand, and assert their rights. So the implementation of the CVBR over the last 6 years has been sporadic and inconsistent. And this is because there has been no major effort to systematically inform citizens of their rights, which would ensure people are less marginalized when they come into contact with the justice system. Criminal justice personnel have not been assigned clear roles and responsibilities in regard to delivering victims' rights. Training opportunities for officials have been limited, and many are not fully aware of the Act and its implications. And data that we have about victims is not collected or published in a consistent manner across the country. So we believe that Parliament can strengthen this Act to hold officials accountable for respecting victims' rights and also require institutions to collect and report data, measuring their compliance with the Act. Parliament should also amend the legislation to guarantee access to support services to victims for their medical, psychological, legal, and safety needs. And this means we need to increase the capacity of victim-serving organizations and community-based restorative justice programs through sustainable core funding to ensure that victims can access services in every part of this country. The last issue I would like to raise, and probably most critical in my view, is the legal recourse or remedy that victims have if their rights are violated. Currently, victims do not have a way to enforce the rights given to them in law. They only have a right to make a complaint to various agencies. So this means that victims have to rely on the goodwill of criminal justice officials and corrections officials to give effect to or implement their statutory rights under the bill. This means victims count on police, crown prosecutors, courts, review boards, corrections officials, and parole boards to deliver, uphold, and respect their rights. But my office continues to receive complaints from victims that are common across all jurisdictions in Canada. Victims report to us that they are not consistently provided information about their rights or how to exercise them. They feel overlooked in all the processes, and they have no recourse when officials don't respect their rights. So I'm looking forward to sharing our progress report with all of you honorable members. We made 15 recommendations last year to strengthen this legislation. And when victims' rights are in law are fully respected, we will help victims recover, we will strengthen the rule of law, we will enhance public safety, and contribute to offender rehabilitation as well. So I welcome the opportunity for your questions. Thank you. Merci, miigwech.
Thank you very much, Ms. Illingworth. We'll now go to Mr. Moore for your first round of questions for 6 minutes. Please go ahead.
Well, thank you, Madam Chair, and thank you, Ms. Illingworth, for appearing today on what is no doubt a busy day for you. And I want to get your thoughts. I know that you've written to members of this committee, but the importance of the review that's contained in the Victims' Bill of Rights. As you know, the coming into force of this legislation was almost 6 years ago, and there's supposed to be a review within 5 years. It's part of the reason why we wanted to do this brief committee study to hear from you and to hear from victims, to hear from other stakeholders on obviously how things are working and what can be improved. So can you speak to the importance that we do the full review that's provided for in the legislation and what you would like to see by way of outcomes? Without prejudging the review, what are the type of outcomes that you would like to see?
Thank you so much. Yes, I think that it's critically important that the review happen. From the point of view of our office, like I said, we continue to receive complaints from victims in every province and territory about their treatment, about the lack of access that they have to their rights at certain times, being provided information about their rights. So we really need to see the legislation reviewed at this time so that we can look at the gaps and the challenges that still exist. And we have highlighted a number of those in our progress report, which I will share for you. But critically, what we hear from victims, the largest gap of the bill in its current form is that there's no ability to enforce the rights within the Act. So I think that's a really critical issue that the review will need to look at, is how do we actually hold the officials and the system accountable for ensuring victims' rights are delivered to them in a practical way. And the other thing that we really hear about is a lack of access to services and supports that people need, including mental health supports. So it'll be important to look at that gap as well across the country, and especially in remote rural areas where there just isn't funding and capacity to deliver all those services at times.
Can you speak to couple things. I mean, I think one of the themes we hear is that, the overlapping jurisdictions, responsibility when it comes to victims' rights. As you mentioned, the Victims' Bill of Rights enshrines in law certain rights, but enforceability becomes the issue. So what do you see as the main cause for someone not being aware of their rights, or them not receiving the services that they should be provided under the Victims' Bill of Rights? And is there, within the Canadian context, some example that you would hold out as a standard by which we should aspire to, or do we have to look internationally for that when it comes to victims' rights? Is there some jurisdiction that you could point us to that you would say, they're getting it right and victim services have been improved in this jurisdiction?
Thank you. So we have a challenge in Canada, certainly because the law is made at the federal level, but the provinces administer the justice system, and they're responsible for victim services as well for the large part. But this is a shared responsibility. The service to victims, supporting victims in the aftermath of violence, is a shared responsibility. So I really want to encourage that we work together from the federal and provincial level to improve how victims are responded to, because like I said, it doesn't matter what province or territory that you live in this country. We are hearing common complaints from victims across all these jurisdictions that they're not being necessarily informed of their rights when they report to the police. They're not aware. So we really need to look at how do we make sure that officials within the system, so those gatekeepers, they have accountability to victims. There are requirements in that they have to uphold when it comes to informing victims, so that it all starts with that information about their rights, so that they can exercise their other rights to protection, to participation, to be able to seek restitution as they progress through the criminal justice system. And I think, I don't want to be critical and say no one's getting it right. I think there are jurisdictions in Canada that are doing a good job, but we certainly recognize that there can be improvements made. And it starts with strengthening this legislation to bring it to give victims a more equitable situation in the justice system, because right now they report consistently that they're overlooked, that people don't provide them the information that they need, that they weren't aware of services perhaps. So we need to ensure that the justice system officials, are responsible for delivering the information, support, and access to services that they need, whether it's protection, safety, housing, mental health, all of that.
Thank you.
Thank you very much, Mr. Moore. We'll now go to Mr. Virani for 6 minutes. Please go ahead.
Thank you very much, Ms. Illingworth, and it's a pleasure to have you back at the committee. Your insights are really invaluable, and I acknowledge, the ceremony you were just at. And I want to ask you about the Indigenous perspective in particular, given that this is so top of mind right now, as it should be. You mentioned that the Victims' Bill of Rights hasn't been assisting the way it needs racialized people, LGBTQ2, for example. I know that you yourself in your work have implemented the advent of an Indigenous advisory circle to help shape your upcoming projects and plans. Could you just speak to a bit about what that is and how it is working? And then I have 2 more questions. So if we can keep each response to about 90 seconds, that'd be great. Thank you.
Sure. Thanks so much. Yeah, so at our office, we have created an Indigenous advisory circle. So we have knowledge keepers from across the country who are affected family members of MMIWG. They are service providers, they are elders, they are two-spirit individuals, they are survivors. They're working sometimes for a provincial association representing Indigenous people. sometimes for federal government, sometimes they're academics, but all Indigenous people. And right now we have all women, but the circle meets quarterly and advises us about the work we're doing. So as we're trying to strengthen victims' rights in Canada and ensure that we're, the voice of victims is being heard by our office, they're advising us on how to do this, on how to outreach to reach more Indigenous communities. That's something that our office has struggled to do, is to build trust across First Nations, Métis, and Inuit communities. So they're helping us to do that as well, and just inform and improve the work that we do, which can include recommendations to government when we're looking at the complaints victims bring to us.
Thank you. And I want to pivot to sort of an aspect of sort of victim safety, which is firearm safety. And I know you've spoken out about supporting expanded red flag laws to include family members, victims, and other community members to allow them to report potentially dangerous individuals, especially in regard to reducing suicides and intimate partner violence. So you know that red flag laws are currently a subject of discussion in Parliament, and that's part of what's considered in Bill C-21, if I have my numbers correct. Could you just elaborate a bit on what red flag laws would do in terms of assisting victims?
Yes, so we are interested in the use of red flag laws to help to potentially remove firearms in situations where there may be a risk to, particularly in cases of domestic violence, to women and children in the home. We have, some reservations about putting the onus on family members to do this reporting, but certainly we do recognize the importance of having sometimes neighbors, extended family members, be able to flag concerns, physicians as well. So right now there's kind of a delay in this process because there has to be an application, I think, to the chief firearms officer to do this, and there can be a delay. So we're really interested in how we can speed this process up to have firearms removed in a situation where there's increased risk, and how perhaps community agencies can be involved in supporting the people who need it, the victims and survivors who might reach out for help, but perhaps they themselves can't report this immediately because it increases the risk that they face to the, by the abuser who may have access to weapons. So how can we do this and ensure that police are able to respond in a more swift and timely manner?
Thank you, Ms. Illingworth. And just lastly, we recently achieved a royal assent on Bill C-3, which is the bill that dealt with judicial training, specifically on matters that relate to sexual assault. And it was widened to consider social context, including things like systemic racism and systemic discrimination. And those, I think, are useful changes in the right direction. But can you comment on sort of what a bill like C-3 does, broadly speaking, in the context of victims, particularly victims of things like domestic violence or sexual assault?
Yes, well, certainly it's very important for judges to have training around the law and on sexual assault and how to apply it. And certainly context is important as well for that. So we're pleased that legislation was passed recently, and certainly hope that provinces and territories will enact similar legislation to ensure that training is applied to judges at the provincial court level as well, because we know that's where the majority of these sort of cases are heard. And, we want to make sure that we can stop the situations that we've seen recently where the law was applied inappropriately, or those sexual assault myths are allowed to invade the courtroom, those stereotypes that are really negative and have a negative impact on the outcomes of justice. So it's definitely a positive that it's passed, and we're looking forward to provinces hopefully following suit.
Thank you so much for your responses. Thank you.
Thank you, Mr. Virani. We'll now go to Monsieur Fortin for 6 minutes. Please go ahead.
Merci, Madame.
Thank you, Madam Chair. And Good afternoon. It's very good to see you here, Ms. Illingworth. I'd like to raise a question that we mentioned on other panelists earlier, namely the families of people who are found guilty of committing a crime. For example, the children of a criminal or the family members of a young person who's found guilty. Does the CVBR consider them as victims according to the definition of Section 2? I would think yes, but I'd like to hear your views on that. And then secondly, which services are we going to offer to these people?
Thank you for the question. So if I understood that correctly, you're asking if families of people who are found guilty of crimes should be considered victims under the bill. And to me, I think that we would have to look at context here, and if the family members of the person who's been convicted are the victims in that situation, then yes, certainly. But it would depend on who the offender has victimized. So certainly we know that there are gaps when it comes to family members of offenders. There are some NGOs who work to support families in this area, but certainly I think we have improvements to make in Canada when it comes to services here as well as for victims of crime.
Mais disons qu'on prend un exemple.
But to give you an example, not a banal example, of course it's never banal, but a more usual example, you've got a man who kills someone he knows, and is convicted of murder and put in prison. Then you've got the children of this person who's been convicted, and these children suffer from the aftermath of what happened. Perhaps they'll be marginalized at school by the teachers, by children, by neighbors who don't want to come close to them. So there is an impact on the family. It can be the spouse of the person who's been convicted. And same thing other way around. If you've got a young person who's found guilty, then his parents may want to help on his rehabilitation, and perhaps will have consequences for their work and with the neighbors and so on. Is this current, or is this something that doesn't exist? Do you never have that type of request, or is this a concern for you as well?
This is not an area that comes to the attention of at my office, but I do understand what you're saying, and I do. We do recognize that having a parent incarcerated is an adverse childhood experience, and the more adverse childhood experiences that people have growing up, and as they're developing, this can lead to negative social and health consequences down the road. So this is a concern. And part of the work that we've been doing at our office is to call for more funding for prevention of violence across Canada, and preventing these sort of traumatic adverse childhood experiences from happening in the first place. We can do a lot more to prevent family violence and these experiences from happening. So I think this is where we can do work collectively to address
Si vous me permettez de vous interrompre.
Sorry to interrupt, but time is ticking away. But I very understand your point, and I quite agree with you. But I don't want to talk about family violence, because of course it's quite obvious there that if the father kills the mother, of course the children are the collateral victims. We can take that as a given. But my point was more about more standard crimes, someone who kills someone else and the impacts. But I'd like to come on to another subject to round off. You said earlier that victims are not well informed about their rights. I think that is a concern. It's an important point that you've made. Do you have frequent meetings on this with people from the Department of Justice or from Public Safety? Is this a subject that is discussed often with your colleagues in other departments?
Yes, it is. And it is part of the work that has been ongoing since my office was created in 2007, but especially since the bill was passed in 2015. And last year we launched our progress report highlighting what we hear from victims across the country. So we have highlighted, and we just launched a recent report as well about access to information for victims and how information is really that gateway or foundational right that needs to be provided to victims because they can't exercise their other rights.
30 seconds.
30 seconds. Are you able to tell me quickly what you're going to do to improve things in terms of information?
Well, I believe that criminal justice officials must be mandated to provide it to victims. So I think the bill needs to be amended to say that, and that's going to make a big difference on the front line for people getting the information about their rights that they need.
On va les informer comment?
And how will we inform them?
Officials, police, crowns, people working in the system, victim services, all across the line, they have to be mandated to provide the information to victims about their rights and services available to them.
Merci, Madame Illingworth.
Thank you very much, Ms. Illingworth.
Okay. We'll now go to Mr. Garrison for 6 minutes. Please go ahead.
Thank you very much, Madam Chair. And I want to thank Ms. Illingworth for being with us today and for all the work that she and her office do on behalf of victims across the country. And of course, express our apologies when we scheduled this session. We had no way of knowing either that we would have such a horrific discovery in Kamloops or that the National Strategy on Missing and Murdered Aboriginal Women would be released today. So I'm sorry that we tore you away from that important ceremony. However, I think this is an important session that we are undertaking here because of the lack of the statutory review. And I wonder if you could just comment briefly on any communication you've had with the minister about the delay in the statutory review and what response you've had from the government as to why this review hasn't taken place.
I have discussed it with the minister, and he's well aware that it's due, and he expects the House leaders to work together to set the review. So we at my office we've sent letters to the House leaders to request that the review take place, and I know there's been some petitions submitted to the House as well. So we're hopeful that it's going to take place soon.
I will consider that homework assigned to me, and I hope that the rest of the members of the committee will also consider that homework to speak to their House leaders to echo the importance of getting that review underway. I know your report from last, I believe it was November, is quite comprehensive, and you've made recommendations for everything from legislative amendments to very practical suggestions on how to get information out. And one of those I just want to talk about, it really did catch my attention. That's your recommendation 13, where you talk about replacing the concept of restitution with the notion of reparation. I think that's a very important concept to introduce into victims' rights. And I'd like you to say a little bit more about what you see as the importance of this recommendation in practice.
Sure. Well, I think that it's very important to recognize that victims of crime suffer a number of losses when they're victimized. So they may be financial, but their safety is impacted, their feelings of security, their overall health, their mental health. So I think certainly the right to seek restitution is important, but reparations, allowing victims to seek reparations is a broader concept. It brings more restorative practice perhaps into the frame. We know that restorative justice can be incredibly powerful for victims to be part of. They have an actual voice in telling the party, the offender, those other members of the community, how this has affected them, how they have been harmed. And we want to see, because Canada has moved towards all of the provinces and territories have endorsed the use of restorative justice, we still don't see it widely enough available. And if we had more access to such programs in communities, it would give victims far more opportunities to seek reparations that are not just necessarily monetary, but ways to address their safety and these other issues as well that I've raised.
Thank you for that. It's certainly that I've met with who yes, suffered financial losses, but the other losses are much more important to them, and to be able to have restorative justice is really what they're looking for, rather than some kind of cash settlement for the losses that they've suffered. So thank you for that recommendation, and I hope we do get to it soon. In your opening remarks, you talked about services to Indigenous people in particular, and this week this is certainly on everyone's mind. And your office has set a pretty high benchmark on how to involve Indigenous people in the work, and I congratulate you on that. But I want to know if you have any comment on federal government victims programs generally, because what I've noticed is there's a tendency to say, well, these are for victims, and that Indigenous people should go somewhere else for special funding. And that there's a tendency to not think about Indigenous people in the general programs aimed at victims. Have you found this to be the case in your experience?
Yeah, I think we certainly need to think about how we can provide more culturally competent and culturally humble services within the realm of victim services. So this includes the federal providing funding through the Victims Fund to agencies to hire Indigenous staff so that community members feel comfortable to come forward. We know that the federal government has funded the Family Information Liaison Units, which have seen a lot of success working with families of MMIWG. And in my view, because this is, these are cultural supports that are available to do work with the families, whether it's gatherings, seeking medicine, seeking information that they need, supporting their healing work. We need to see more of this. They need to be permanent, they need to be funded, and more widely accessible. So let's give money to NGOs who are doing this work to hire diverse staff that they need. So Black, Indigenous, people of color, there needs to be representation in all of victim services so that community members feel comfortable to come forward. And then we can also fund these very specialized programs as well, like the FELOs.
As I mentioned, how are we doing for time, Madam Chair? We've got some delays going on here.
You know what? Go ahead for one question. Go ahead.
Okay. In my opening remarks, I mentioned that certainly there are some members of the Canadian public who suffer as victims of crime at much higher levels: Indigenous people, racialized Canadians. I use the term SOGI, sexual orientation and gender identity community, and also sex workers. And so I wonder whether you have seen an adequate response from the federal programs that takes into account this differential impact of crime on certain communities.
I think there's always room to improve and put more money here. I think I saw in the House this week, there was a comment that $28 million has been allocated through the Victims Fund over the last 6 years around the Victims Bill of Rights. And that's programming that goes to provinces and territories and NGOs. And to me, that is not nearly enough funding to do the work that needs to be done to support communities that are overrepresented as victims, as you said, and we need to provide more specialized services, and certainly we can improve that at the federal level, at the provincial, territorial, and the local level as well. But it's a shared responsibility, and we need to keep talking about this.
Thank you very much. Thank you, Mr. Garrison. We'll now go to Mr. Lewis for 5 minutes. Go ahead.
Thank you, Madam Chair, and thanks very much, Ms. Illingworth. I think this is the third time I've had you as a witness somewhere. So as usual, your testimony was very in depth and very well thought out. So I thank you for that. You had mentioned in your opening remarks that the system often overlooks the victim's concerns as it focuses on the accused. and that too often authorities are not trained to inform victims about supports and resources available. So can you elaborate on what you have heard and how we can make changes to ensure authorities are knowledgeable of supporting for victims?
Yes, sure. Thank you. We have heard that victims are not always treated as such when they come forward to report crime. Certainly, we know that in the case of sexual assault, there's particular challenges with being believed when survivors come forward to report to police. So we need to make sure that victims are offered the information right from the outset about their rights. They're offered first of all, inform that they have rights. Second of all, inform that there are services to support them, including restorative justice services if they're interested in that. It's important to provide that information so that survivors have choice at the outset and they can decide whether proceeding through the criminal justice system is actually what they want to do. And so we need to ensure there's proper training for officials as well. Whether it's frontline at reporting, whether it's in the courts at the end of the system, corrections and parole, so that at every stage, people are given the proper information that they need to exercise their rights and make the choices that are best for them in their circumstances.
Very well. Thank you very much for that answer. Madam Chair, through you. Back to the witness. So I believe there's been situations where offenders are able to access social media and take it to posting pictures and comments about their victim or victims. Do you have any thoughts on how offenders use social media to continue to harass victims?
Yeah, I hear every day from frontline service providers who are concerned about technology abuse, especially in intimate partner scenarios. We hear a lot about it when it comes to young people and consent and not having consent around sharing intimate images. So this is an ongoing concern for sure, and a violation of people's rights when either being stalked and harassed through technology and very fearful. It causes immense fear as well. So we need to do more to recognize all the harms that can come from social media and access to different forms of technology to commit further abuses against victims, particularly, in the context of intimate relationships. And again, we need to ensure training on these issues so that people who are responding understand how serious it is and that people need support who are going through this. And it's a matter of safety in many instances. We don't want things to escalate to the point of serious violence or someone being killed, which has happened in the past.
Thank you very much, Madam Chair. What do I have left? About 1 minute? 1 minute. Thank you very much. One final question, Ms. Illingworth. Can you expand or talk about the restitution orders? I know you had mentioned that in your opening remarks. So talk about the restitution orders and how government should assist in the enforcement of court-ordered restitution. Thank you.
Yes, happy to. That's one of our concerns, and we have a special report coming out on this issue later this year. But victims of crime tell us that when they have a court order for restitution, so depending on where you live, it falls upon the victim to enforce this order. So people tell us that they have to hire lawyers to garnish wages. They have to figure out where offenders are living. They have to serve them with papers, hire legal representation rate, all at additional cost when they're trying to recuperate what was stolen from them or what was, losses that they suffered during the crime. So this is problematic. We know that in provinces that have programs that assist with enforcement and collection of restitution, that these are very successful. And so Saskatchewan, British Columbia, I think Nova Scotia has a program as well, but we need to see similar programs implemented in all the provinces and territories to help victims collect what the court has ordered.
Thank you. Thank you, Mr. Lewis. We'll now go to Mr. Sarai for 5 minutes. Please go ahead.
Thank you, Madam Chair, and thank you to Ms. Ainsworth. In 2020, the progress report, the Canadian Victims Bill of Rights, you mentioned that the vast majority of persons who are victimized of crime in Canada chose not to engage or cannot engage in the justice system. How, in your opinion, might strengthening the Bill of Rights impact the willingness for those who are able to engage with the justice system?
Well, I think it's really important to acknowledge that people don't trust the justice system right now. People are fearful about coming forward. They feel that they won't be believed. They've seen how other survivors are responded to. So if we strengthen victims' rights, if we ensure that victims have the ability to enforce their rights, so make sure that they can seek a remedy if their rights are overlooked, this is going to give people increased confidence that the system is going to take them seriously when they come forward, and that people are actually responsible for not causing further harm. So that's really important. Right now, we hear from a lot, especially newcomer families. We hear from Indigenous families, racialized families and individuals that they don't feel safe to come forward to report what has happened to them.
Sorry to interrupt, just because of time. How do you think we could actually, in concrete terms, enable them to do so? I mean, I have a writing that describes everyone you just said. How do you empower them to come forward and utilize not only their rights but to voice their pain and their issues?
We need to improve training for officials in cultural humility. We need to have more third-party reporting programs that allow victims to go to community agencies that they trust and they have been working with to help them to report crime to the police. And when people start to see that they actually have rights that are real, and not just statements of principles, that people can be held accountable. For example, if their rights are overlooked. So perhaps it will be through judicial review, perhaps it will be other sort of administrative reviews that will, when we amend the act eventually, but this will give people confidence that they're going to be taken seriously, they're going to be believed, they're going to be supported as they go through this system, because there's been a change of culture in this system to respect victims' rights and law.
Thank you. You're in recommendation 11 of that progress report. You suggested a national public education campaign using TV and social media to inform Canadians of their rights as victims of crime. Can you elaborate more on how this might look and what else we can do to ensure that Canadians know their rights and who especially those who become victims of crime, and understand and what resources are available to them?
Yeah, this is a critically important gap that we had following the passage of the bill. And we continue to hear, like I said, that people just don't know that they have rights as victims of crime. So we need to put some funding into public education campaigns, public legal education around the rights that people have should they be victimized. Nobody ever expects that this is going to happen to them. And so when it does, they're thrust into a really complex system. And so if we can increase the public awareness of the rights that people have, they're going to be less marginalized. They're going to feel more comfortable to come forward. Oh, hey, wait a minute. I heard this, I heard this somewhere. Maybe it was on TV, maybe it was on the radio, maybe it was on social media, on Facebook somewhere, but I do have rights, and they can better recognize what's happening to them, maybe is abuse or violence, and they can come forward to seek help and feel that the system is going to take them seriously and support them as they move forward.
Thank you. How much time do I have, Madam Chair?
15 seconds.
Okay. Well, thank you, and I'll pass it over to the next colleague.
Thank you very much, Mr. Sarai. We'll go to Monsieur Fortin for 2.5 minutes. Merci.
Merci, Madame la Présidente.
Thank you, Madam Chair. Ms. Illingworth, I'd like to hear about the victims of crimes committed abroad. Are there residents of Canada, Canadians, Quebecers who are victims of a crime that's committed abroad? Are they also covered, in fact, by this program that's been set up under the Bill of Rights or not? And for Canadians and Quebecers who are victims of a crime who are actually abroad themselves when the crime is committed, can they benefit from a certain amount of protection and services under this Bill of Rights for victims of crime?
Thank you for that. The Canadian Victims Bill of Rights applies to crimes committed in Canada only. So Canadians and Quebecers who are victimized when they're traveling or living outside of the country do not fall under this this bill because it applies to our justice system in the context of our criminal justice system. However, there is a funding program through the Department of Justice that allows victims to access some emergency financial assistance when they've been victimized abroad outside of Canada.
Et à votre avis,
And Ms. Illingworth, do you think that's acceptable as it stands, or should it be changed? Do you think there should be coverage, or should we include something in the CVBR for people who are victims of crimes committed abroad? Should that be included?
Yeah, this is a tough question because it's difficult for Canada can't give rights to people in other criminal justice contexts. So I think that's why it wasn't included. What we suggested in our progress report to address this issue is if we amend the bill to guarantee support services to all victims of crime, that would allow people who are victimized outside of Canada, when they come back home, to be able to seek support through services that are on the ground in the community that they live, or federal services, what have you, and ensure that people can get support when they're at home and are aware that they can get funding to travel back to participate in criminal justice processes abroad as well.
Avez-vous beaucoup de demandes pour des...
Do you have many requests? Okay, thank you, Madam Chair.
Mr. Garrison, for 2.5 minutes, please go ahead.
Thank you, Madam Chair. It appears I'm having some internet connection problems here on my end, but I will go ahead and try. Ms. Illingworth, in recommendation 8 of your report from last November, you talk about making the Office of the Federal Ombudsman for Victims of Crime the single authority with jurisdiction to review complaints by victim of crime with regard to any federal department or agency. So my question is about your relationship with the Department of National Defense Sexual Misconduct Response Center and the things that I've heard in the Defense Committee as the defense critic about a lack of confidence in the Sexual Misconduct Response Center and its independence.
Well, the recommendation in our report is more around the process of making complaints for victims. Is very complex. So they have to first complain to the agency, that they are having an issue with. And then if they're not satisfied with the response that they receive, then they can come to our office, for example. So a lot of times victims are discouraged from making complaints in the first place because the processes are overwhelming. There's a lot of paperwork to be completed. And so the idea around that recommendation was, let's have one office where it's very clear that victims of crime can make a complaint and try to have it resolved, and just to make the system more trauma informed and sensitive to people who are, it's asking a lot to file a complaint and go through those processes and wait those out. So with regards to the SMRC, I know that they're doing good work to support survivors. We've had, we direct military sexual trauma victims there if they contact our office. But I do understand there's some hesitation because they report to chain of command. So I think the SMRC does a lot of really good work when it comes to counseling and supports and things like that, and it's a very important service. But when we're talking about complaints about bigger systems, like that needs to be an outside office that can take those and review those independently.
Thank you. Thank you very much, Mr. Garrison. We'll now go to Mr. Cooper for 3 minutes. Go ahead.
Thank you, Madam Chair, and thank you, Ms. Illingworth, for making yourself available today to be here. I want to ask you two questions or 2 points regarding the rights of victims in the context of parole board hearings. The first is in the COVID context. You wrote back in April of 2020 to the chair of the Parole Board of Canada early in the pandemic that victims were being denied their right to participate in person at parole hearings, that they were told they could just submit a written statement, all the while in certain instances offenders had assistants present in person. Now, I see that since then, more recently, the Parole Board of Canada has set up a piloting video conference solution. Can you just comment on, are you concerned that victims are still being denied their rights due to COVID-related concerns, or are you satisfied that this has largely been addressed or completely addressed by the Parole Board? And second of all, on a non-COVID related matter, there's a concern from many victims about the lack of transparency with respect to information regarding dates with regards to eligibility for things like temporary absences, parole, or statutory releases. In particular, just a lack of an explanation as to how those dates have been arrived at. And as a result, in many instances, victims have been caught off guard, but there's all of a sudden a hearing that they had no idea was about to happen. And obviously, it can have a profound impact on vulnerable victims.
Yes, thank you so much. So firstly, yes, the problem of victims not being able to attend physically has been addressed for the most part with the ability to participate through teleconference or video conference during the pandemic, which took a little while to get going, but has been up and running now for almost a year, or I guess over a year, or just around the year mark. Participation is actually up. So we think that this is positive and it should remain as an option for victims of crime because people are feeling safer, I think, to participate from home. Their travel's not involved applying to the fund to access funds to travel. All of that has been eliminated, and it's actually quite efficient to participate from home. So I think that's a good thing. It must continue after the pandemic. Victims need choices. Yes, some will want to attend physically in person at the prison, but many don't want to do that. They don't feel safe to do that. So the video conference and the teleconference option are very important. And then with regards to eligibility dates, that is a challenge that corrections and parole have in terms of delivering information that victims can understand to them. The sentence calculation process is very complex. And so I know right now they're working on, the national office is working actually on some information to help decipher this and make it more plain language for victims about how eligibility dates are calculated and things like that. But when you do register as a victim with Corrections Canada and Parole Board, you are provided the dates for your offender at that time that they will be eligible to apply for day parole and passes.
Thank you very much. Thank you, Mr. Cooper. And now lastly, we'll go to Mr. Maloney for 3 minutes. Go ahead.
Thank you, Madam Chair. And Ms. Illingworth, thank you for being here today, particularly given the important conflicts you have. We're all very grateful. So if I am the victim of an assault, it's obvious I get the benefit of the rights in this act. If I am the teenage child of a victim of assault, I meet the definition of victim and I am entitled to the enumerated rights in the act. What is not clear to me is if I am the teenage child of the perpetrator of that assault, whether or not I am entitled to the benefits of the rights in the act.
Yeah, my assessment would be that you're not.
Okay. All right. That's what I thought, because I had asked this question, I posed this question to the earlier panel and they weren't clear on it. You said earlier that the two important characteristics of victims, particularly if they're children, are security issues, financial instability, emotional challenges, I think you added. Those same problems are experienced by a teenage child of somebody who's committed a crime and whose parent may be in prison for a long term. Wouldn't you agree with that?
I do, yes.
So don't you, in your opinion, do you think it would be fair to add children or family members of people who have committed crimes to meet the definition of victim under the Act?
I think we'd have to think carefully about that and how to do that in a way, because certainly there are harms that result from a parent being incarcerated, absolutely. But yeah, I'm not sure if I know the answer to that and how to add that to the Act in a way that that doesn't, that wouldn't be offensive to the people who are harmed by the acts of the offender directly. Do you know what I'm saying?
I completely agree with you and I share your concern. I'm thinking particularly of children, because there are many children who there's no other way of looking at it. They are innocent victims when they have a parent who's committed an act and now they are left in circumstances that if through no fault of their own, they have to live with the stigma and the problems, whether it's emotional or financial. So I think it would serve two purposes. One, it would help those children and give them the services we're talking about with victims, but it would also help break the cycle, because often you'll see is with children who have parents who have been incarcerated that they are they're more disposed to committing crimes themselves. So I'm running out of time, but I appreciate your opinion and I'm grateful that you agree with me. Thank you. Thank you, Madam Chair.
Thank you very much. I love that Mr. Maloney times himself. Thank you, Ms. Illingworth, for your time today and for your very compelling testimony, as well as answering questions from members on this very, very important topic. With that, members, I will adjourn this meeting until next time. Thank you.
Thank you very much.